Hi, I'm Tiffany. Me and Carly are responsible for our two questions. I'll be presenting on question 1 and Carly will be presenting on question 2. So there are two issues for question 1. The first issue is to advise on the potential sentence that Don will face if he convicted. So he is currently charged with Section 17 OAPO, which are wounding or causing grievous bodily harm with intent. So first of all, as stated in HKSAR and Gamble, we need to first consider the starting point and then the aggravating factors based on the severity of the offense, and finally the mitigating factors for Don. So as HKSAR and Lam Si Mui stated, that the starting points of the sentence can be adjusted upwards or downwards with aggravating or mitigating factors. So there is no tariff here, meaning there is no minimum sentencing for these cases, but as the court in HKSAR Mui Fun Fun stated that all offenses contrary to Section 17 OAPO are serious because they all contain the ingredients that the offender intended to inflict really serious injury at the time. So the maximum sentence would be life imprisonment, and it would only be sentencing the most serious wounding with intent cases as laid down in the San Fan Yong case. But cited the case Che Hoc Lam, usually the range of these cases will fall between 3 to 12 years imprisonment, although everything will be depending on the particular facts of each case. So what will be the key factors in determining the appropriate level of sentence for wounding? The court in HKSAR and Roca Sijuan gave out a list including the nature of the offense. There was a use of weapon and the circumstances of its use, the defenseless state of the victim, and the effect of the injuries suffered by the victim. So if there is severe residual disability caused to the victim, extremely severe sentences will, with a heavy deterrent element, may be warranted. In SJ and U.S. Sen case, the defendant was imprisonment for 5.5 years because the victim's ears were cut apart by a chopper. So, which is similar to our current case where Vaughn's face was seriously chopped and he is now totally blind. So, the starting point here would be 5.5 years. So, moving on to the aggravating factors. The UK Sentencing Guidelines Council has identified a list of aggravating factors, which includes offenders operating in groups or gangs, because it indicates that a higher culpability. And the case of R and Y Hin state that triad offenses of any kind are very serious offenses. Also in Chen Chung Tek, the court that stated that if a wounding has triad overtones, this will necessitate greater deterrence. So in Don's case, there are triad members involved, so therefore a deterrent sentence may be warranted. So the second aggravating factor here would be the previous conviction. So HKSAR and Chen Qixing states that the gravity of the offense may be increased by a relevant previous conviction, the criminal record. So premeditated would also be aggravating factors. So the court in HKSAR and Lai Kam Tong states that if the evidence shows that an offense is premeditated and well planned, this is a very serious aggravating factor because the person who plans crime is often more culpable than someone who acts on impulse. impulse. The court in R and Lee Cameron further said that no question of leniency may arise if the offense is premeditated. So in this case, there are 3 aggravating factors to increase Don's sentences. So let's see if there are any mitigating factors available that may be balanced out or may give a discount for Don. So in the UK sentencing guideline, it also lays out the mitigating factors with less culpability. So the fact that the offender only played a minor role in the offense is less culpable. Although Don is a joint enterprise, he has to bear the secondary liability, but Don was only the driver. He didn't really chop Vaughn's face, and he's not really involved in injuring Vaughn. So another mitigating factors for Don could be argued that all 3 of the previous convictions of him were at least 16 years ago, and he is no longer a triad member since youth, which indicates that he wants to stay away from trouble and is now living his own life, which he is now married with 2 young children and has a proper job, which he has his own car cleaning firm that employs 3 people, and he is also the sole breadwinner of the family. And usually the court will look into the family and financial situations of the defendant and take these into account before sentencing. So also cooperation with the authorities could be a mitigating factor. In C and HKSAR states that the court will give a usual discount of 40%, including the 1/3 for guilty plea, for the defendant who provides assistance to authorities without giving evidence. So in the case of HKSAR and Choi Tak-man also states that if the defendant has also given truthful and material evidence, the court will give an usual discount of 50%. So Don gave out the 2 attackers' actual names and addresses, would be considered as cooperation with the authority, the police. However, he is not willing to plead guilty. He would lose the 1/3 account. So citing the C and HKSAR case to calculate his sentence, the discount range would be 40% to 50% minus 33% of the 1/3 guilty plea for him. So the court would likely to give him 7 to 10% discount. The conclusion here is, after balancing the aggravating and mitigation factors, the starting point 5.5 years would be lowered to around 4.5 to 5 years, which is around 7 to 10% discount. So the second issue here is because Don was refused bail at the magistrate court, and he would like to ask for bail again. So the general rule of the bail right is a continuing one. It is guaranteed by the Basic Law Article 25, Bill of Rights Ordinance Article 5, and Section 9D of the CPO. So unless there are indications that Don would fail to appear on the required days to court, or he would commit other offenses during bail, or would interfere with the witnesses or obstruct the course of justice, otherwise bail should not be refused by court. But of course, under Section 9G, subsection 3 CPO, the court can be refused bail for Don's own protection. In the current case, possibly it's because tribe members are involved, and if he chooses to testify against them, he will need a protection from the members. But here, Don wants the bail so badly, he wouldn't care about his own protection. Then there are 2 ways available for him to apply bail. The third method is under Section 9G, subsection 11 CPO. If the court refuses to admit an accused person to bail on the first occasion, The court can consider the same reason of first occasion at the subsequent hearing. So Section 9G subsection 11 is for making the same application twice only. But here we don't know from the fact that how many times did Dawn made the application. But as we can see from the fact that the committal proceeding has already took place 4 months ago, and his trial is in 10 days, so it can be safely assumed that he would have had at least 3 appearances. First appearance would be when he was arrested within 48 hours. The second was the appointment of return day, and the third could be on the return day. So therefore, assuming he had applied bail twice already, so now he couldn't use the same reason to apply bail again under Section 9G subsection 11. So Dawn can possibly rely on method 2, which under Section 9G of the CPO, to make an application to the High Court, which is the CFI, before next appearance to review the decision of the magistrate to refuse bail. Yeah, that's it for our part. Thank you.